Minister of Legal Affairs and Attorney General Anil Nandlall is positing that the Chief Justice, Madam Roxanne George, did not err in her ruling when she dismissed one of two election petitions filed by the APNU AFC in August 2020. As a matter of fact, Nandlall said that the Chief Justice's decision is a good one.
I believe it's a very, very good judgment, and a judgment that will guide us in the future.
The Attorney General stated that the law is clear, rigid and very strict with regards to late service on a respondent, and that the court rightfully established that the second named respondent, David Granger, was a proper party to the matter, contrary to arguments preferred by APNU AFC attorneys.
Now, the law is very clear. When election petition documents or the election petitions are not served within the time stipulated, the law is very strict, the law is very rigid, and the law says that the petition is a nullity and must be dismissed, that the court has no jurisdiction to deal with a petition which is affected by non-service or late service in relation to any of the documents.
Meanwhile, Attorney-at-Law Mayo Robertson, who spoke with this newscast via telephone, expressed the view that the National Assembly Validity of Elections Act at Section 204, Chapter 104 states clearly that a respondent is one whose interest is in conflict with the request of the petitioner, and that this was not the case with David Granger.
Our law specifically says a respondent is a person whose interest is in conflict with the interest of the petitioner. And we believe that Mr. Granger's interest is not in conflict with the interest of the petitioner.
Robertson is one of the attorneys representing the petitioners. He had filed Petition 99 of 2020 on behalf of his clients, who were alleging in that petition that the 2020 general and regional elections were poorly conducted, while highlighting instances of voter impersonation, as well as missing statutory documents, among other irregularities. Robertson further stated that it was expected that Petition 99 would be bogged down by the respondents, since the nature of that petition would have made damning revelations about the March 2, 2020 elections.
We always expected that this one was going to be bogged down. We expected that the respondents were going to make every possible effort to make sure that this petition was not heard and resolved within a short time frame.
Attorney-at-Law and Shadow Minister of Legal Affairs in the National Assembly, Royce Dilford, Senior Counsel, shortly after the ruling was handed down by the Chief Justice, said that his party would appeal the ruling of the Chief Justice, as the National Assembly Validity of Elections Act at Chapter 104 does not specify any time limit within which the named respondents are to be served. Wendell Badri, HGP Nightly News.